So, I think I've pretty much got Parliament sussed out now, what is actually going on. And I know that's a bit of a bold statement to make just casually, right? But if you think about the Bill of Rights, the whole point of having a Parliament is for addressing all grievances and amending and strengthening the laws, right? But particularly it says amending and strengthening the laws, right? The whole point is you had two knights in the Shire elected to attend from all over the country. Because they had king and council, they didn't always have a parliament. Sometimes the king chose not to call a parliament, but they called them, and they called them in because they wanted, to approve certain, monies and certain spending and revenue and things like that. Because they all had to approve it together, right? That was the point. If it could just be the king and his council who approved it and did it, they wouldn't need to call everyone in. But there was this thing where they had, to get Parliament's consent to it, right? Which means, the whole point of the coming in. So if they're just putting certain things through now with these SI, statutory instruments, and putting them on the table and no one opposes it and it goes through, what's the point in calling all the MPs, right? Now, the thing is that when we've got Parliament, everyone's always been able to petition. The whole point of the commonality petition the king, right? But then when they call a Parliament, we select and elect members to go in to represent the areas, right? And that's the whole point in the Speaker petitioning the King for the rights and privileges, because they're going to be doing the work full time all the time, right? Rather than us only doing it if we've got a grievance or issue to the King, which is meant to be, protected and privileged. When we elect the MPs, that's going to be their job when they go and attend Parliament while it's on and then come back, right? But obviously Parliament's kind of permanently in session now. The thing is that what we've ended up with is gradually, starting from around the 1920s onwards, the petition levels, our engagement, the public engagement, just literally dropped off the map. Around the time the telephone was invented, but there was various other reasons. But Erskine-May, the law and rules haven't changed in Erskine-May book from 1920 onwards. The books were all the same, right? The law and procedure, particularly in standing orders and in the Erskine-May book. But the thing is that if the petitions really nearly died out, proper petitions, right? I know there's a lot of demonstrating and protesting really is causes them as the Parliament, but it's harder to get them to accept that now if there's not a petition. I think they wanted to try and attempt to get rid of the whole thing, but the private bills was the other alternative. When you get the private bill put through, that was the other track. So you've got the public and private business, and there was a lot of both. But now there are only 1 to 2 private bills getting put through per session. It literally is hanging on a limb, worse than what the normal public petitions was, under 100 every session, or 150 to 250 every session or less, right? And now there are only, a few parliamentary agents, but all these parliamentary agents seem to be in the circles of these administrative and constitutional lawyers, who are the ones who are advising Parliament on what Parliament's policy should be and how they should run the place. So it seems to be run by the administrative lawyers, not actually by our elected MPs or committees, really, which is quite dire. This is how we end up with these illegal policies, right? For number 10, through for petition. This is the thing. This is what AI worked out, and this is something that I don't think AI has got wrong, because I admit that when we were doing the research, Gemini is really good now. Actually, it's really, really good at searching and finding things and correcting points. When I was using it, I guess we were rushing it a little bit. We definitely weren't doing it completely and totally wrong, and it wasn't made up. We made a few slight errors, and it was actually my own opinion and my debating and my reasoning has always actually been the stronger, solid point, right? And it's the data integrity that Gemini is bringing back, right, and checking, which has been the problem. And then Replit, I passed it on to Replit, and then it ended up mixing some of the different data up together, which should have been separate, and now I've ended up with a table of cases, which is kind of like they're not fabricated, they're real cases, but some of the information is wrong about the outcomes of some of them, just because it got the separate separate sections misconstrued and mixed up together. So I've got to correct it all now, but I'm going to do a completely more thorough, better job of it. Now, coming back to Parliament, right? We've calculated with the AI that it's like a very small percent of laws that get enacted now are actually MPs are voting on. Because and what a good term and identifier for this is, like, you know, when like the big issue, because they have those like big issue sellers, but that's actually true. The idea behind, you know, big issue, that's actually all MPs are really doing now, other than being strong political brokers who have got a lot of political influence and can write letters and get the public behind things, right? Like cheerleaders or mascots or whatever. Supposedly they're meant to do casework and get things sorted out for people. Now, there is a very small percent, I think it's less than a lot less than 5% of actual laws that are getting enacted are getting voted on. And all the rest is just getting automatically put through on a conveyor belt, like statutory instruments and things like that. And what they're actually, the small amount of laws that actually, you know, that is the big issue. So they'll get like something like the right to life, and then that'll dominate the sort of headlines and MPs debate and discussion, like the right to life, or, you know, the right to privacy, or we're going to take away the juries, right? And those are the big issues. But there were only a number of them at the time, and they're sort of promoting those like billboard sort of policies to get the public sort of like riled up for and against it. Meanwhile, all this other conveyor belt of legislation is getting put through in the background automatically, getting laid on the table, and none of the MPs are opposing it because, you know, apparently they'll never stand for the party again if they go against their own party, right? So they're all like under the possession of their own parties, not an individual person in Parliament, and they don't oppose any of that, right? I mean, so it's, and all those are amending the laws. They're all amending the laws. So really, if you think about it, the words Parliament is there to redress all grievances and amending and strengthening the laws. Actually, the 95, 98% of laws that are getting put through, SI is automatically on a conveyor belt, which MPs don't vote on. That is amending, changing and strengthening laws, but it's not making brand new ones. It's not actually really making brand new laws. And that's the whole point of the MPs in the chamber are meant to vote on it, right? But they don't oppose all this huge mass going through. So it makes you think, right? If MPs are called to Parliament to represent us for amending and strengthening the laws and redress all grievances, we aren't really addressing grievances because public petitions and e-petitions doesn't have any grievances on it. They're only policy suggestions. And MPs aren't getting engaged in amending and strengthening the laws because they just stand back and don't intervene because the party tells them not to, as everything is getting automatically put through. So we're not actually doing any grievances or amending and strengthening the laws. MPs aren't getting involved in any of that. They're doing local casework, which the council didn't sort out, and they're just being a political broker, being a mascot representative, cheerleading for and against these handful of big issues that are kind of like, taking up everyone's attention while all this other stuff is going on in the background, and like the ones that everyone thinks, this is going to make it matter or not, like digital ID and stuff like that. Now, I actually think that because they're actually amending an amendment to a law or strengthening it automatically with these SIs, and MPs are just standing there doing nothing, and they're not having petition. They won't let us do petitions of grievance and e-petitions, the modern, convenient way of doing it, and they don't answer you or reply hardly for normal paper petitions, right? We're actually, when they're getting elected, being sent all the way into Parliament to turn up, and they're not really acting to settle our grievances or acting to amend and strengthening the laws. They're standing back and letting, Keir Starmer or whatever, or now it's Andy Burnham, put stuff through in a conveyor belt and just stand back and let it happen because that's what their party tells them to do nothing, right? So they're not actually travelling all the way to Parliament and attending for redressing all grievances and amending and strengthening the laws. What they're doing is they're voting on new, different laws. And actually, if you read Sir Edward Coke's book, right, the Institutes, they were saying, they were warning against novelties, which is new or different laws, right? Novelties and new and different laws. So, actually, amending and strengthening laws is done automatically now. You don't vote on it, really, because that all goes on. And what I think is, if they manage to actually get rid of petitioning as we know it and any idea that you might even have a privilege when you're doing it in the process, and even MPs don't even really get theirs upheld anymore, right? And it's just random policy suggestions that, you'll get through if you're lucky. And that's on a side menu to these big issues they've got going, right, which are cheerleading. We're not actually really sending the MPs there really for anything productive, except these distractive big issues while it's all going on in the background. Once the private bills, like these 1 to 2 private bills, the last 1 to 2 get gone, and there's no actual paper petitions that they're reckoning that there's any use to gather evidence or use a legislative process or protected procedure, right? You're left with, you've got the right to make a policy suggestion and collect some signatures on it, and if you're lucky, they'll debate it, right? And that's definitely not a private member's bill or even any of the big issues that the parties themselves are, propping up, getting rid of juries or digital ID. So I actually think that the MPs attending Parliament and us electing them, and that's their full-time job, so it's meant to be a privilege when they're doing it. But our right to plug into that through private bills or public petitions, right, settlement of grievances, if that disappeared and it wasn't there, what are you actually left with in Parliament? All that you're really left with is an automated Parliament. And it's amending and strengthening the laws automated, and the parties have got possession of MPs and they tell them not to, don't you dare, oppose our nice little standing orders we're putting through. It's all automated. Now, doesn't that defy the point in when the King and Council, were just doing it all and then they called a Parliament? What's the point? What's the point in calling the MPs in to vote on something if you're just going to put everything through automatically and they stand back and not act? There's actually no point at all whatsoever. You might as well go back to King and Council. We might as well elect Andy Burnham as the king, and then his cabinet just puts stuff through, right? And then everyone else just votes on these public petitions, and no one actually has any power or authority at all to challenge anything. And then who's controlling the internet? What's popular? I've got two live petitions at the moment, and I get off to a good start. I've got some signatures coming in. I just got short of 1,000, but I've been busy doing other stuff, right? So it's not the fact that I got them going, and now I haven't had time, right, to concentrate on them. But I know they're there, and I'm going to get some promo for them. I'm going to actually try and get them to. My goal is to try and get them to 10,000, so at least I get a response from the government, right? But one of the petitions actually is intervening in something the council's doing, and it's a live case, so it should actually stop the council doing what they're doing. But they're not actually acknowledging it, and this is the whole point of what I'm trying to prove now, is the municipal intervention. The parliamentary private bills and private and public business is supposed to intervene in municipal council business, right? And that's what the Parliamentary Papers Act can also do as well. And that's what I'm in the process of proving, but it's just trying to get the AI to do it properly. But I'm doing a proper thorough job now, because a lot of those parliamentary journals, they're not all available. And when AI searches it, sometimes it gets this thing called truncated, or it doesn't actually completely get all the data properly. But I'm getting it all together properly now and getting every single privileged case instance out of the entire history of England that's together, and then getting it all sorted, which I didn't. I should have done that. I should have done that in the first place. But I thought AI was looking through them and searching. We did quite a good job. To say that like Gemini was doing it off the cuff and just having a look through, for like basically just like having a rake through the box to see what's in there. But what I should have done is made some consolidated data sets and got everything together, so it didn't have to next time it goes back, like the link's broken or it can't get on the website, I can't find the source. And we need to get those select committee of public petitions records, which ProQuest have got. And I don't want to have to go to, the library and sit at the computer and manually search it, because I want to search through all of the there's 900,000 petitions in there, which is going to take a long time to look through. I want to actually get the disk with the data set. And then there's all those Middlesex Court, the Middlesex Quarter Sessions and the London Archives. There's a lot of stuff that isn't scanned. There's a lot of stuff in National Archives, like there's Treasury solicitors, the other Middlesex files and cases. There's quite a lot of stuff which is not even scanned yet, which is important. But actually, it's looking like I've just got the computer going in the background at the moment, and it's actually getting every single... I should have done this in the first place properly, which I'm doing it properly now. Every single privilege instance, and we're getting it all together. And I've already looked at the statistics. There are loads and loads. I mean, that case table I got, it had 450 cases. We're looking at thousands of cases now. There are actually thousands of cases. And then some other cases got pulled into it, which were just examples in the discussion. And it's looking like there are a lot of cases, a lot more than we had before. And these are all going to be indisputable because they're all in the actual journals. I think what the AI is going to do when we do it properly, with a decent model and with a full data set available, not it's just online, and sometimes you can sometimes the website's bot blocked, so you can't actually get the AI to go on it. It's blocked them, so they have to sort of go through that Wayback Machine to when it wasn't blocked, and all these kind of hassles and interferences. But I'm actually looking at the data now. It's quite clear that I think that AI will probably prove that, Erskine May, when it reads the entire parliamentary history, it will probably say that Erskine May is not entirely telling the whole truth, right? It won't say Erskine May is wrong, but it will say that it's only a fraction of the truth, right? And probably say the same for John Hatzell's precedents and proceedings. He gave a small selection of cases, but they were nowhere near the full extent of what is on the record, right? And what the law supports. And then when you get onto these other books like Ohud Phillips and these other more modern constitutional and administrative law books, they're not telling the whole and full truth about it. Some of them are actually erroneous. Some of them are a little bit more honest than the others, but they're not 100% correct on everything. And I know that I'm not wrong, because I've got, the reasoning that I've been using, particularly when it comes to the wording of the Parliamentary Papers Act, and even in the debates on it, what even is protected. When they were discussing that act, they were talking about evidence that people are bringing, and documents and things like that. So, the way that Parliament is going, the direction it's heading, this is what people need to understand. They're going for an automated process where the MPs are kind of just frontmen reps for the big issue, whatever the big issue is at the time, and some of them are cheerleaders for and against it, but they don't actually really have that much of a say in it, because these big issues are just 1, 2, 3 or 4 things that they can distract everyone with while automating all this stuff through, which they're going to do for digital ID and AI and all the rest of it, and we're not really going to have a say in it. And effectively, the administration of the government are going to be running things. And this is the argument that we've got in with the local councils now. The local council authorities, the legal staff of the local councils, like in our council, Kirklees and Oxfordshire, it's effectively like a local version of the Solicitor General or Attorney General, right? They're meant to advise the local council, right? And then they're not correctly advising them because they don't know the law. All they know is the modern law when they went to university, and we know that the university hasn't been teaching them everything about this, and it exists. It is law. It's in the law of England. It's enacted. It's in force. And the problem with the modern administrative law is this, right? They did this thing where they wanted to cut down on us using our powers through private and public business to Parliament. And they wanted to make some procedures available within the Acts, right? So they legislated many of the procedures. So now you don't have to complain to Parliament or pursue a private or public law against it, because we'll do you a little process in the Act where you can, oppose things. And this is where, in building and planning law, local building and planning law, this is where the applicant, right, the developer or the builder, if the council knock him back and, don't approve it, he's got a right of appeal to Whitehall, and all that is enacted within law, right? But what do we get? What do the objectors get? But this is the thing. In a local consent, the local people are trying to defend and protect the local area against what has been proposed, right? It's a defence. Now, we've got that municipal word, municipal councils, right? But then you've got civil and criminal law. But local council law, municipal, is civil, right? But it's not a tort civil dispute. But this is the thing. In criminal law, which was dealt with by the local councils on the committees for crime committees at the town hall, and when we didn't have a town hall, before we had a mayor and a town hall, we had the quarter sessions coming round, and there usually was a jury there and a justice, right? Because it wasn't the petty sessions, and they'd made the decisions on what money gets spent on the roads and what cottages get built and stuff like that, right? What you read is this. We're not talking about criminal law when you've got an accused and then they defend themselves and you've got witnesses. The victim is not the person who prosecutes, because it's the King's law. The King's law's been broken. The victim is merely like a witness, and the prosecution are prosecuting the offender for breaking the King's law, right? It's not actually the victim who's prosecuting them. They broke the King's law, and the victim effectively is like one of the witnesses, right? Okay? Because something happened. Now, but with the council, and with council approving cottages being built, or asking if they can have money to spend on the roads or repair a road or whatever, right? It's in the area of civil law. And this is the roots and foundation of the municipal council. Now, the thing is, if a developer wants to build something, right, and they're putting a case before the court, and then the jury, usually in a civil matter, would be deciding it, there's a judge there, right, makes the order, etc. Where does the objection come from? Well, it comes from the local people, because they might be defending and protecting an area. Now, I've checked this, right? In tort law, in civil tort law, Mr. Smith versus Mr. Johnson, right? If Mr. Smith owes Mr. Johnson some money and he takes him to court, only one of the persons started the court case, right? One person started the court case against another person. They're just the respondent, right? Now, if the respondent, right, loses and the claimant wins, the loser has a right to appeal, right, they have a right of appeal, even though they didn't start the case and it just came from nowhere. Someone said, all right, you know, like, you know, you owe me, you know, some money, or, you know, you've got my things and I'm claiming that I own them, I want them back, or whatever it is, right? The person who is, you know, getting a legal case against them, right, they have a right of appeal, right? Both parties, right? In a criminal case, if a person gets prosecuted by the Crown, right, and they lose, right, or if they win and they, if they get acquitted, right, if they're not guilty, the victim doesn't appeal. The victim doesn't appeal. It's the Crown Prosecutor, but usually if the jury decide, then, you know, it's the community who've done it, right? I don't think the Crown Prosecution Service can appeal to the High Court if it's a jury. I think they did it in, like, Angela Ditchfield's case to the High Court from the Magistrates Court, and they also did it with that, you know, that recent milk case, Good Law Project, with a milk thing on blocking private land. The Crown Prosecution Service tried to push it to the Supreme Court, but apparently there was no case to answer, right? But so what was the situation with building and planning, right? Well, the thing is, if someone wants to build a huge jet plane factory next to the village and the people really don't want it there, right? Don't you think that if they objected to it and lost, it's absolutely insane and ridiculous that they wouldn't be able to appeal it? Right? And there's nothing they could do about it. And actually, even if the people in the village won, right, and the council voted that they weren't going to allow, like, a massive airplane factory to in the village, then the applicant can appeal to, you know, Whitehall or whatever, to the government department, and they can appeal it, right? But the local people who are going to be affected can't. That would be absolutely ridiculous. This is what happens when processes and procedures get enacted into a law, and we say, oh, we're going to deal with it under the Act, right? But then this is the problem also with the Ancient Monuments Act, right? That Ancient Archaeological Areas and Ancient Monuments Act is there to protect ancient sites, period. It's there to protect them. It's not there not to protect them. So with our ancient site, you know, when the council are in collusion with this, you know, developer, right, and I'm building on a protected ancient site, and then, you know, the council approve it, apparently the local people can't do anything about it. But it's not normal development law. It's not normal development or building and planning law, right? What it actually is the Act has got a procedure in it for people to use, because they made it in the Act, right? And in that particular Act, if you're in Scotland or Wales, anyone, that means one person or the whole town or the whole country, can apply, which means they can, like, petition the Secretary of State or the authority, which is HES or that Cowid place in Wales, right, for a protection order certificate. Anyone can ask for it. Now, in England, they don't have that, but they have to have something sort of similar, a little bit different, but a different procedure in England, right? Now, what the council, which we think they're trying to make out, right, is that only the person who owns the land, right, or, you know, their family or the guardian can have an interest in future ownership, which is absolute rubbish, because you don't need to have an interest in future ownership if you already freaking own it, right? If you already own it, why would you need an interest in future ownership if you already own it, or if you're likely to inherit it, right? You know, you might not be interested in it, but you're still going to own it or inherit it anyway, right? So it would be, think of the logic. Why would you do that? You wouldn't. So, and I've checked through this with the AI, and the councils, if the council want to try and make out the definition and meaning is the same as in other property law, they're wrong. It's not, because anyone can have an interest in future ownership, right? And you make and declare it through objections, right? And it can be anyone, because that would be a similar but slightly different process to what they do in Wales and Scotland, like can be anyone. So you just wouldn't have it where it could only be the person who already owns it, or like the guardian, because it narrows it down to so few people that it's pointless to have it in the Act, right? Now, that should stop the council. It should have stopped the council from voting on it, should have stopped the council from passing the order, but they totally ignored the process in the Act. So that's evidence now that these acts they're passing and making, and they're saying, oh, well, you don't have to do a public petition to Parliament, and you don't have to oppose the council or a private bill, because we've made you this little act which is convenient, and it's got all these like processes and procedures in the Act which can deal with it all. But they're not. They're not dealing with it all. The local legal services in the council are not upholding and applying the processes and procedures in the Act. They're failing to. And the councillors are voting on things that, that when someone's effectively stopped them or blocked them, right? Now, this is where the main argument comes in with these modern, contemporary legal staff who've been through the Professor Mark Elliott School of Law, through the Mark Elliott Public Law book, right, and learned all this, constitutional administrative law, etc., which doesn't tell you the full story. They can't stop us doing public petitions to Parliament or private bills against or opposing the council. They can't stop you because it's a constitutional legal right. And that the processes and procedures in those acts they've made, they're just convenient resolution processes. They're not overriding of the fact that you can go to Parliament, right, and you can just oppose the council or try to get the law changed or put a grievance in, right? Because in that act, it says that you can petition the Secretary of State anyway for intervention, right? And you can do it straight to Parliament. So why they've actually got, effectively, the Secretary of State, every single public, from 1973 to 1974, when they abolished the Petitions Committee, anyway, up till 2015, every single public petition got laid on the table in Parliament for ministers to comment on. And that includes, Secretary of State and the whole Cabinet, right, to comment on it. So those petitions would have got a response from the Cabinet government anyway, including the Secretaries of States for each department, right? For every single paper petition, you didn't have to get 10,000 signatures. Now they're not even bothering responding to us. So this is the thing, right? And this is when we get to like Tim Bearder of Oxfordshire Council, right? When you've got Raise the Colours, who are doing a political campaign, right, to stop illegal immigration. And we know there are petitions for that, and we know that that's what they're doing, like, because he's investigating illegal immigrants, because he got the videos for it. And the council are shutting them down and saying they can't put their flags and promotion up when we've got acts like the local, the 1993 Act for Noise, which says that if it's a political demonstration, the council can't oppose it. They can't act against it. Well, that means that they can't seek or pursue an injunction either. Now, if they were banned, if the council are blocked for pursuing an action against a democratic, a political demonstration, right? What would be the point, right, in being able to, what is the point, right? This is where Tim Bearder, right, and Robin Green, right, have lost the plot. And I don't care how much money Robin Green, KC Barrister's on. I don't care about Cornerstone Chambers and how much millions they're making, right? Why would you be able to shut down a political demonstration for noise? Why would you be blocked? Why would you be blocked from shutting it down from noise? Because it's exempt, right? And it's in the Act, it's equal to the army. Let me clarify on this, right? Why would you have an Act which explicitly said that the council cannot shut down a political demonstration because of noise, but then you would say, well, we can shut it down because of the signs that they're putting up around the place. That defeats the point. It's like, we can stop you from having something on your T-shirt, but we can't stop you saying it, right? It will be pointless. And that's why the local, the 2007 Control of Advertisements has, in Class F, you can use any act, right, which is your 1688 Bill of Rights. All prosecutions and commitments are illegal, which puts it on equal par with the noise and sound from the political demonstration. And I don't know, Tim Bearder, right, is naive and he's a traitor to the Constitution of England. His staff at Oxfordshire Council they're a sandwich short of a picnic. They're using public money to actually pay for profit Robin Green KC to go to the High Court and persuade and mislead and coerce naive Mr. Justice Diaz to even put the order through when they can't do it. And this is why we're using the Parliamentary Papers Act 1840, because it's a proceeding of Parliament is raise the colours. It's to get action on the matter of deporting, detecting and detaining illegal immigrants, of which there are multiple petitions on it, right? That's what they're raising awareness of. And it immediately intervenes in the order. Now, our issue in the local area is the Ancient Monuments Act, right? And, it failed. The Ancient Monuments Act prescribed procedures failed. The council ignored it. The legal services in the council ignored it. And the councillors voted it through. It was the last thing that Labour did. It was the last thing that the Labour Party did, because then they all lost their seats. The whole Labour Party lost their seats. It was the last thing that they did. So, like in Oxfordshire, we've got, Tim Bearder and his legal team, spending money on Robin Green. And in West Yorkshire, we've got the legal services totally ignoring the Act. And then when I'm trying to use parliamentary jurisdiction and I have got an actual live petition, and I'm claiming it, it's not like, you see, the situation with me is I've actually got the petition and it's mine and it's published and it's live and I read it down on the paper, I claimed it, right? And I've actually been in the solicitors, sworn an oath and sent it into the council. And they're still saying there's no such thing, it doesn't exist, right? And that's like what Tim Bearder, Oxfordshire Council are doing. No, this is not a political demonstration. This is not a political protest. We can shut it down with the High Court, right? But, we can't shut it down for noise, but we can shut it down for their signs. Well, no, because what would be the point? If you can the whole point is so you can't shut it down. So why would you be, if you can't shut it down because of the noise, because it's on par with the military, right? Why would you be able to shut it down for its signs and notices? It makes no sense. And I'm getting sick of the High Court. I'm getting sick of Mr. Justice Diaz and the Chief Justice. I'm not saying they're stupid, but they're either playing games with us, and they're in the process of doing some tomfoolery with us, right? And they're taking us for a ride. Or they are literally a sandwich short of the picnic. They've lost the plot. They've got a big quadrant missing out of their whole legal argument. And that's when we get back to the, Professor Mark Elliott School of Law and Erasmus John Baldwin and all these books which don't fully tell you the whole truth, right? And they're trying to make out that we can't oppose the local council authority with privilege to Parliament, and the local authority can't stop us or shut us down from that, right? And that's the point. So we've got to challenge these legal services staff, because they are not fully and completely educated, and I strongly believe that they're not impartial. I think that they're passionate, either Labour or Tories, and they get a job on the council, and, it's a secret control of council, because they don't have to, they're meant to declare their interests, right? And I don't think they are declaring their interests. I think they've got serious interest in undermining our rights. and I think they've got serious interest in getting the town developed and getting all these building developments put through, and they're all for it, right? And when we try and oppose them, they're trying to make out that, we don't have any legal basis at all. There is no such law. It doesn't exist. And we're talking nonsense, right? When they were the ones who were ignoring the prescribed procedure, which is meant to be given to sort it out, right? And even when it comes to building and development, generally not scheduled monuments, right? You can't steal and take away our right to object to something because it's an inherent right. And that's the thing. I think they've pulled the fast one on us with building and planning and development. They've tried to make it so like there is no objection. It doesn't exist when it does. It does exist because whatever decision the council makes, anyone can oppose that authority. Now, just because they've made developers a little appeal process in an act does not mean that you can approach it from outside of the act, right? Straight over the top of the head, right? The council made the order. We're going to oppose them to Parliament. Either get a bill or act against it or do a public petition because we went up putting up with it. And this is why Labour and the Tories have tried to shut us down. Now, Reform UK have come in. All of the Labour Council have been replaced. And now we've got a brand new party in the council. Now, either they're going to continue to be told what to do by these, legal advisors in the local council who literally that means that they're owning the council and they're a major influence. That's like, we're meant to have MPs to go into Parliament and vote on things, right? They're meant to make up what the law is, not the clerk. The clerks are only meant to be advisors. The clerks of Parliament and the staff of Parliament are only meant to be advisors, right? The Speaker's voted in by the other MPs. But it turns out that all these constitutional and administrative lawyers are the ones who have been advising the government, and they've been literally shaping it, and they've been the ones who have been like nudging, elbowing us out and our rights and stuff, and trying to lie and make out that we don't have any when we blatantly bloody damn well do, right? And that's where I am with it. And we're going to end up with the councils are literally automated. The councils are effectively now near automated by these long-term permanent staff. And then you get these bollards who are put in place, these customer services staff, like Chris Reed, who's a human bollard. You might as well just like pin a face on a metal bollard, right? And they're just they're installed. You can't vote them out. You can't vote them out. You can't change them. It's a bollard. It's been installed to block you, right? While the council gets on with its business of it's going to redevelop that town if hell freezes over, right? And they're going to have a new sports centre, police station, blah, 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 the rest of it, where the hell freezes over, right? McDonald's, KFC, this is it. And the objection is just a joke when actually, no. There are many occasions where people have gone to Parliament and they've got the whole thing shut down. The I don't know if it was Glasgow or Dundee, but there was a dispute over a police station or something like that, and the privilege protected the whole waterfront, right? And there are multiple municipal cases that I've got now where the privilege protected the whole area, and that clearly is applicable to when it comes to ancient sites and monuments, like protecting the whole area around it, right? Not just the actual site itself, like the surrounding area, like with Old Oswestry Hill Fort and things like that, because they've been putting building and developments up around it, what people have objected to, and even said that they're petitioning to Parliament to on record on the objection, and the local council have ignored it in both instances, right? They're ignoramus. So I've had enough of these legal staff. The legals, and I've complained to the SRA and the Solicitors Regulation Authority, are not there to help us. They're another set of bollards, right? They're another set of installed bollards. So we've got to try and get this sorted out. This is where I am with it now. These legal staff are in contempt of Parliament, and they're not fully and entirely educated, and they're not impartial. They're not unbiased. They're not declaring. They're failing to declare their secret interest, which is to push this administrative agenda, which is effectively the same school as this background statutory instruments getting automatically put through because no one opposes them, right? And the councillors are not the councillors need to learn more and be more interested in learning about the law themselves. And actually, you know, in Parliament, the clerks only advise. The whole House, the MPs can disregard the clerk's advice, and that means the local councillors effectively can disregard the legal services if they want, right? Effectively, if they want to, I don't know whether they'll face a judicial review or not over it, because they've got all that coming into it now, which complicates things, and it makes it like, but it's still only another, you know, court of authority. But when you take it to Parliament, it's higher than the council or a judicial review, you know, and they're not letting us have it when it exists and it is there.